good morning. Thank you so much, Daphne, for joining me this morning. I'm coming to you from Senior, and I appreciate you coming on board with me to answer some very important questions family usually have about the elder care process when it pertains to law. So Daphne, would you mind introducing yourself for me?
Sure. I'm Daphne Vasol. I'm an elder law paralegal with Angels of Elder Planning. We are part of the HWK Law Group in Timonium, Maryland, right at York and Seminary. I've been working in elder law since 1998. I started in estates and trusts doing document drafting and then moved on to long-term care Medicaid planning.
Oh, very good. And those two things, legal and Medicaid planning, I think are probably the questions that we get the most out of anything else. So I'll just go ahead and jump right in and start. What are those core documents that if I'm a family, I am going to need for my parents?
Everybody, regardless of age, should have at least a simple will, the power of attorney document, and an advanced healthcare directive. Those three documents are key to anybody's planning regardless of age, but most importantly with our seniors right now, because a lot of them have not gotten those basics done. They just figure, oh, my kids will get everything. I don't need to do it. It's not how it works anymore.
And I like that you said everyone. So it's just not me looking after my parents. I have to make sure I'm taking care of that myself as well.
Absolutely. My kids, as soon as they turn 18, they sign a power of attorney because I told them, mom and dad can no longer help you once you're 18. I can't call and schedule a doctor's appointment. I can't help you at the bank with things. And the minute I told them that, they're like, oh no, mom, we need your help. So I'll sign it. I'll sign it. And that way I keep it handy just in case I should ever need it. But I learned that many years ago, a fellow paralegal's son was in a terrible motorcycle accident and there were no documents in place. He was young in his 20s. And nothing was in place. And that's when we all, the group of us who work together, the paralegals, all realized you really need this regardless of what your age is, because you just don't know what tomorrow brings.
Absolutely. Wow. Yes, that kicks things in gear for me having a 21-year-old son. So I get it for sure.
Yeah. Yeah.
So define for me, we talked about those documents. I have a durable power of attorney that I looked up a little bit and I've heard it a lot. General power of attorney versus springing, which is a new term that I'm hearing.
Yes, and it's not one that's used often, and we usually shy away from it. It depends on the circumstances. So first is your durable general power of attorney. If you know, or if you recall, back in October of 2010, the courts devised a Maryland statutory form power of attorney document. Reason being, all the little financial houses that are out there, the Morgan Stanleys, the UBS, TIAA, Kraft, they all wanted their own special power of attorney signed by the client. As you know, in elder law, that is not always possible. If they already had a power of attorney, but mom could no longer sign and they needed to access the account, there's no way mom or dad could sign a new POA just for that specific business. So the courts had enough and they said, we're going to do this statutory form power of attorney. You can use it at your financial institutions and take care of your business. And if anyone challenges it, they're going to come before a judge. I think it was the most brilliant idea ever. It covers your basics. Now, it's not the in-depth minutia that not everybody needs, but it covers the basics. So it's a good starting point. That would be the real estate, tax returns, getting in and out of the bank, the safety deposit box. So all those basics are covered in a durable general. It's effective immediately. And in the statutory form, you have the option of a termination date. So if you only want someone to have it for a period of time, say you're going out of the country for 3 years on leave, if you're military, you can put a termination date on it. Most people opt to just have it terminate at death, which is when it terminates legally anyway. The other one is a limited power of attorney. People have probably heard of these when they do real estate transactions. You sign off a limited power of attorney to your broker or agent who's selling the house, just so they can take care of a couple little things pertaining to the house on your behalf. Saves you a little time and effort and makes it a little bit easier in the process. So limited just gives specific power for 1 or 2 basic transactions, nothing major. It's very short. Next is the springing. Springing depends on your situation, because a springing power of attorney means you have the document done and signed, but it cannot take effect until you are deemed incompetent by 2 doctors. Once you are deemed incompetent to sign or handle your own affairs, then it springs into action. That's why they call it a springing. It doesn't spring into action until you need it. So once the doctors deem that you cannot handle your affairs, then it springs into action. That's a little bit trickier because you have to make sure that whoever the agent is going to be does their due diligence in getting the documentation required, and anywhere they submit that power of attorney document, they also have to show those doctor's certificates stating they're no longer able to do it. So as a rule, we always stick with the durable general power of attorney. It covers all the basics. And then if you're doing additional planning, you definitely want to have that power of attorney done by a law firm. There's things in there it does not cover. You can't hire an agency like mine to help you with Medicaid planning and appeals cases with that document. You can't do a gifting strategy for Medicaid with that document. You can enter a safety deposit box, but you cannot entirely close out a safety deposit box. So there's pitfalls, but it covers the basics. But absolutely, if you're doing more in-depth planning for our seniors in a nursing home, then you definitely want to have an attorney draw up that power of attorney document.
Now, is that healthcare agent separate from these documents, or does it tie into these documents?
No, they are always segregated.
Okay.
Once upon a time, gosh, 30 or so years ago, they used to do a dual power of attorney covering medical and financial, but that hasn't been done in years and it no longer is done. You have to have a completely separate document. The beauty of the healthcare directive is not only does it appoint an agent that's covered through HIPAA to be able to speak with all of your different medical professionals, but it will also outline your end of life wishes. So if you have a terrible stroke and you're brain dead, do you want feeding tubes? Do you want IV water? Do you want to be resuscitated? Things like that. It covers. So the doctor has no question, but you have to make sure the person you appoint as your agent is strong enough to uphold your wishes. So I've had clients where, say, the son, he was a mama's boy, but he's also an accountant. So he did financial power of attorney. Daughter, she was a nurse, saw it every day. She did medical power of attorney because she knew she had the strength to uphold mom's wishes, even through her emotions, if mom decided she didn't want to be kept alive by additional artificial means. So you have to be very careful when you choose these agents for yourself.
Do you ever run into those situations where the parents don't want to relinquish their rights to make decisions, and
Absolutely.
how do you approach that? I've had families say, well, they're really stubborn and they can kind of do banking, but they're not going to the doctors or taking their medication. And I'm just like, so how do you approach that with those families that clearly
I've noticed a lot of my elder clients, they don't listen to their kids, period. No, you're my kid. I raised you. I wiped your nose. You don't know anything. So I get a lot of that, unfortunately, because we all know it's not the truth, but that's how they feel. So when a paralegal or an attorney comes in from the outside to sit down and meet with them and explain it, and they hear it from our lips instead of their kids, even if we're just saying the same thing that the kids told them, they're usually a little bit more inclined to move forward and listen to us. The other issue I find is that, well, no, I don't need it. I'm fine. But when I explain to them the what if scenarios, and usually this catches them every time, if you do a power of attorney now for a couple $100, you'd need it later. Everything's taken care of, no problem. If you refuse to do the power of attorney and then you have a fall or a stroke or something where the children need to step in and help out, and there is no power of attorney and you can't sign one, you're going to have to go through a court guardianship proceeding. Could be anywhere from 3 to 6 months, and you're looking at $3,000 to $5,000. So a lot of people, since I work with the middle class, we watch our pennies. I work with people just like me and my mom, my family, and they want to watch their pennies. So if I explain to them that it's only going to be a couple $100 now versus several $1,000s later, that also helps them feel a little bit more inclined to sign. And then finally, I say, you can sign it today, but in order for your child to utilize the document, they have to physically take the original to the bank, have them make a copy and send it through the legal department. So even though you sign it today, you can lock it away and you're safe. It doesn't mean your child needs to use it today. They just need to know if anything happens to you, where's the document? And
Right.
it's in the safe with my deed and my other papers. So if they sign now, that doesn't mean the child needs to utilize their authority at this point, because it is a very powerful document. You know, giving all that authority to someone is scary, but you can always do it in advance, lock it away until you actually need it. That usually keeps the parents' fears down a bit too.
And you answered that question that was going to be next about what happens when my parent becomes memory impaired. That's why you're doing this early. This is such a proactive decision. It sounds like just because of that reason. Yeah, you
Absolutely.
never know.
And a lot of the parents already have their children either as joint owner or an authorized person on their accounts, just to help them with general banking and bill paying, especially with the technology age where a lot of it has to be done online now. So a lot of the children have some sort of limited access to the accounts already. So the parents usually aren't too bad. They don't push back too bad. But yeah, I get those really stubborn ones who don't want to sign. But you just really have to appeal to common sense is all it is. Be rational.
Yeah.
And then they kind of see it as a black and white issue. Okay, well, this makes a lot more sense. I'll just lock it in my lockbox. If they need it, they know where to find it.
Right. Okay.
You know.
Thank you. Thank you for explaining that. And that goes right into the parents that still have a home, and many children, adult children are asking, should I put my parents' house or deed in my name now?
That is a case-by-case situation for that particular question. There are different ways to do things. One thing that I like to encourage is that if your parent is younger, say they're newly retired in their 60s, maybe that parent considers doing something called a life estate deed with powers, meaning they have the power to do whatever they want with the house. Nothing changes there. But by having that life estate designation, it names a remainderment, just like life insurance would name a beneficiary. If mom passes away suddenly, she can have a beneficiary on the house. It passes to the child. They get a step up in cost basis, so they're not hit with capital gains tax. It's a nice probate pre-planning, so you don't have a probate issue. If you have someone who's a little bit older and having health issues, but they're still at home, they haven't gone to the assisted living, they're just getting a little bit of care from the kids, things like that, and they really, really, really want to keep the house in the family because maybe dad built it with his own two hands or the childhood memories are strong, they can consider a life estate deed without powers. And that means mom or dad, whoever owns the house, they now give up their right to grant it, mortgage it, convey it, sell it, whatever they want to do with it. That right would go to the remainder person. So if they name the kids and they decide 10 years down the road they want to sell the house, the kids just sign off on the sale of the house. However, after 5 years being titled in this manner, the house is considered to be protected from a Medicaid perspective. So it is a pre-planning tool for Medicaid. It's called a 5-year out strategy because Medicaid requires 5 years of all financial records and documents. So by doing something like that early, and then 10 years later, you need a nursing home, you have the peace of mind of knowing the house is going to go to the children as you designated, and the state isn't going to be able to put a lien against it that way. So, and then there's the kids who, well, maybe because of COVID, job situation is poor, they've been living with mom, paying all the bills. Then there's the situation of maybe you want to add them to the title with mom. Then we've got situations where mom really can't afford this, but I love her and I have the money. I want to keep her in her house. So if you're doing a 5-year out strategy and you do this early enough, you might be able to transfer the house into a child's name. If not, and you're kind of coming up on that nursing home pretty quick, you want to find out what the tax value of the house is, and the child can buy the house from their parent at tax value. So maybe the real estate market right now, as we all know, is pretty much booming, but the tax value of the house is only $250,000, even though you could sell it right now for $600,000. So if you've got a big difference like that, the state of Maryland looks at how the state tax regulations are running. So you look at the SDAT value, State Department of Assessments and Taxation, look at the value of the house, and the child could buy the house outright from the parents. Then they
Mhm.
have it forever and ever, amen. Maybe it opens up some cash flow for mom or dad if they're going to assisted living. Now, the money the child paid for the house can be utilized for mom or dad's care at an assisted living or 24-hour home care, whatever they choose. So there's a lot of different options when it comes to the house, and everything is case by case. And we
Okay.
would sit down and run it past the attorney as well to make sure all our tax consequences are in order and nobody's going to be in a bad situation. So this is elder law is a group thing. You need
Okay.
accountants, you need lawyers, you need paralegals, you need the social workers, you need the doctors and care providers. So it takes a village to do the
Mhm.
planning. And
Mhm.
that's why we're at the law firm. We've always had our overseeing attorney, Nicole Hewitt, and we just have more access now to additional attorneys, financial advisors, tax accountants, things like that. And we all work together to make sure get the best outcome, because it's not going to do any good to do this planning and then you get a tax bill at the end of the year for $30,000 you can't pay. So you
Right.
have to look into every angle. You can't just cookie cutter. Yes, this is what you do.
Okay. That's very good. And again, this goes back to planning as early as possible to make sure that you are lining everything up that could be the most beneficial to you and your family, it sounds like, no matter what it is, even when it comes
Absolutely.
to the home. Um,
Absolutely.
you talked about planning ahead for Medicaid because of the 5 years. So how does that look overall in regards to the house? Thanks for explaining that very detailed and case by case. I get it because everyone has a different situation. But if I want to apply or have my parents apply for Medicaid and they have no assets or very limited income and there is no house,
Mhm.
what am I doing there? There's some funds. What should I be doing now? Because they may need a nursing home later, because it is some illness.
What you want to look at is what accounts they do have. How are they titled? Do you have your power of attorney? And has that power of attorney been put on the assets that they do have so that you can access it when the time comes? Also, a lot of my clients from the past generations have liked to have multiple bank accounts because you've
Mhm,
got one for the property taxes, you got your Christmas club, you got your daily one, you got your money market or your CD, because the
mhm.
CD game was big in the 80s and 90s, who had the best interest rate. So you want to go through and make sure you know what assets are out there and how they are titled. That is a huge step in the planning. Then if they do have the multiples with the bank accounts, see if you can consolidate things down a bit to make it easier to track the paperwork. The biggest thing with Medicaid is the paper trail. So you want to hold on to 5 years of bank statements. And again, we're in a technology age. So if you go online to help mom or dad with their banking, or they're on paperless, make sure that you are downloading those statements and saving them on your hard drive so that when the time comes, you can produce 5 years of statements for the state of Maryland. Otherwise, the banks can charge anywhere from $3 to $7 per statement, and you need
Mm.
60 months.
Wow.
That's a lot. And there are a
Yes.
lot of banks that will not waive that fee, even though it is for Medicaid. They want to make their buck too. So you have to
Right.
be very careful. That's the biggest thing. Don't let mom and dad shred all the stuff or
Okay.
throw it in the fireplace.
Right. All right. That's a good point. And now with everything being online, if as an adult child I have access, I can pull some of those things out. Or do you know if they go that far back online? I never looked at that. Daphne.
Depends on
I'm
the
sorry,
bank.
Daphne. Mhm.
Yeah, it really depends on the bank that you're with. Some of them will go back 7 years because if you think about it, the IRS requires 7 years of documentation should you ever get audited. So
Mhm.
some will go back 7 years. Some will only go back as far as the changeover. Like I had a client with Howard Bank that recently got bought out by First National. So when I went online and set up the new First National account for her, it only had 4 statements on there, 4 months of statements. So the crossover period between the two banks was very limited. So
Mhm.
that's another thing you have to watch out for. What if your bank gets bought out? You may have been with Howard Bank for 20 years and you can get those records online, several years worth. There's always at least 3, usually more, but you can always
Mhm.
get at least 3 years. A lot of them are at 5 years now, again, because of Medicaid. And
Mhm.
7 is the standard for the IRS, but every bank is a little bit different. And when there's a takeover like that, I don't know that any bank's really going to take the time to upload records from the old bank that they just took over. So you have to be careful with that to make sure you are downloading them and saving them onto your computer.
Mm-hmm. So for those parents that do have some assets and they are trying to preserve funds for the possibility of needing long-term care, what advice would you give those folks on just being prepared?
They would absolutely want to call into my office or another elder law specialist for Medicaid planning. Again, because every case is very, very different and unique to what that person's needs are. So if your mom or dad has specific needs, but you're keeping them at home, mom or dad has specific needs, but they're going to assisted living, or they're going to a nursing home now, but we think they're going to rehab and come home afterwards. There's so many scenarios. There's no way to go through them all. So please, please, please seek help. Call over to the Angels. We've been doing this. My business partner, Sherry Rush, and I have been doing this for over 20 years. We would be happy to sit down and meet with you and help. Good hour and a half consultation will open your eyes wide about the specific situation you are in and give you a guideline as to how to proceed.
Okay.
It's definitely worth an hour and a half of your time to sit down and discuss the situation with someone, because we have had cases where I've protected hundreds of thousands of dollars. You don't know what your options are until you know the scenario.
Exactly. Okay, very good. And you covered putting, the name on the bank account to kind of protect mom if she needs help, and looking at our adult children as well. So this is the question, and this is my last question. Do I need to sell my parents' house for them to move into a nursing home? And will they need to turn over all of those assets? Kind of a three-part question. And then will the nursing home allow my parents' income to go to their bills, or will they want all of that? You can kind of start where you like with that question, Daphne.
That is an excellent question. I get asked it all the time, and so many people come to me and go, oh my God, they're going to take the house. What am I going to do with that? Because maybe mom's in the nursing home and dad's at home. He's still doing well. Well, that's a misnomer. They no longer take the house from under you. Now, I remember when I was 12 years old, I had a great aunt in a nursing home. She had to go on Medicaid, and they did. They literally took the house from her. But that was, over 30 some years ago. That no longer occurs. So let me clarify this, how this works. So if mom and dad are married and they're both living in the house, and one of them goes to the nursing home, in order to qualify for Medicaid in Maryland, their combined assets have to be under 27,460, I believe is what it changed to this year. So 27,000 or less in total liquid assets. Income is not considered for this. But then the next piece, of course, is the house. So as long as you have a well spouse living at home, they're not going to take your property. They're not going to place a lien on your property. There is someone there who needs to be there. So you don't have to worry about the house in that manner. Now, if you're in a position where it's just mom in the house because dad passed a few years ago and mom needs the nursing home, now your option is, if you would like to retain that house while she is in the nursing home, we have two scenarios. One, she's in the nursing home for a limited period of time receiving therapy and intends to return home. And then you have the scenario where she's gone to the nursing home and she cannot return home, but you still want to hold on to the house, or at least you need more time to prepare it for sale or decide if a child is going to buy it. You do have that window of time. What the state of Maryland does is it places a lien against the property. So the money they're paying out each month towards mom's care will go on to the lien. So say that's $8,000 a month, and then it continues to accrue until the time of sale. At the time of the sale, Medicaid is repaid, and then the rest of the proceeds would go to mom, and you'd have to do some new planning. So you'd have to figure out a way to protect the assets from the sale of the house. So it's a multi-point question on that one, but no, the short answer is they don't just take the house anymore. But it is something you can consider, because if they're going into a nursing home, nobody in the family needs or wants the house. You can still apply for Medicaid while you're getting the house ready and emptying it out, maybe having some repairs done before it's sold. And then it sells, and now mom has $200,000 in the bank because we sold the house, but she's been in the nursing home for 8 months now. Medicaid's going, everything's hunky dory. So you notify the caseworker that the house has been sold. They will stop the Medicaid, and then you do what's called a spend down. So you could protect assets, you could buy your funeral and burial services with it. Maybe mom's doing well enough that she could now move to an assisted living. I have had that happen quite often when they've been in the nursing home for several months, but because they're eating properly, they're taking their medications regularly, they improve, and they may only need custodial care, which is, feeding, bathing, dressing, medications, basic items that can be handled in an assisted living. And they might be more comfortable there too, especially if they can find a nice, smaller assisted living. A lot of my clients opt for that. They like to know that mom is sitting on the couch watching Family Feud and can smell dinner cooking in the kitchen at the smaller assisted livings, and they're more comfortable. So that's another possibility. Maybe they are doing better, and the nursing home comes back and said, there's really no medical reason for mom to stay in the nursing home. She doesn't need a nurse 24 hours a day. She just needs a caregiver 24 hours a day. So again, it's a very fluid planning process because everything is based on the medical needs of the parent. So you have to sometimes take a step back, take a breath. What's good for mom? Okay, let's sell the house and do assisted living since nobody wants the house. So mom's income plus the money from the sale of the house will maintain her in assisted living where she's going to have a better quality of life for many years to come. So your next question piece of that was about the income. So let's go back and I'll explain the spousal piece. In the spousal case, dad is at home, mom is in the nursing home. Medicaid requires that your income is paid over to the facility each month so they can show that you are paying as much as possible towards your medical expenses. And since Medicaid is a payer of last resort, then they kick in and cover the rest of the bill. However, in a spousal case, mom's income may be able to be deducted and taken over to dad to keep the house going. So if dad only gets maybe $1,500 a month in income, but he's staying in the house, there's a calculation to be done. It's called a spousal income allowance, where some of mom's money could be retained by dad each month to pay the household services and bills so that he can stay in a home and live in a manner in which he's accustomed. There are cases where there is no cost of care or payment from mom to the nursing home because maybe the person out in the community needs all of her money to keep going. I do see that quite a bit in my older ones who were homemakers and they get $500 a month in Social Security. Dad was the breadwinner, dad's in the nursing home, but depending on the calculation, mom might be able to keep all dad's money each month to keep the house going. Another piece to that puzzle is, but what about my health insurance? What am I going to do with my health insurance? I can't afford that. You can. State of Maryland, when they're determining what's called this cost of care amount, your income less expenses that are allowable. And one of those allowable expenses are your health, dental, vision type coverage, Medicare RX plans, different prescription drug plans. So you get $500 a month, but you're spending $250 on your health insurance program. So that leaves you $250 a month. That's what you would pay to the nursing home, less another $84, because state of Maryland has generously given everyone $84 a month of play money. So that's for your hairdos, or if you're getting a phone in your room, cable, if you like to order out slippers, cookies, things like that. So you get $84 every month as play money. That's how they see it. But aside from that, the rest of the income does come to the nursing home to pay for your care. So it is a huge, overwhelming, multi-step process with a million scenarios. And I can honestly say at this point, I think Angels has pretty much seen every scenario there is. We've had everything from mom and dad to just mom to estranged parents, out of state, bank accounts in Europe and Japan. All kinds of things have happened over the years that we've been doing this. There really isn't many scenarios left, I don't think, that we haven't seen and helped the family deal with.
Okay.
multiple properties, jet skis and boats. That's something that you have to work on selling off. Businesses and corporate interests. So I had one not too long ago where dad was a barber. He's in the
Mm-hmm.
nursing home, but he still has the barber shop. Now it's not making any money. He's pretty much just letting barbers work out of it. But
Right.
again, you had to deal with business interests there.
Mm-hmm.
So there are a lot of things that you really need to discuss with a professional to make sure you're doing it right. Because if you mess up, you're not going to get Medicaid, and that nursing home's charging about $12,000 a month. So how are you going to pay that? You've
Right.
got to make sure you do it right and follow the rules. Medicaid rules are 2 5-inch binders thick. It's called COMAR, the Code of Maryland Regulations.
Mm-hmm.
So you want to find somebody like me who knows all 10 inches of the rules.
Yes. Yes.
Yeah, because
Yes.
some kids are like, well, I'm just going to put the house in my name. Well, you can't, because that's considered a gift. And if you don't do the transfer the right way, mom's never going to get Medicaid and you're on the hook for that bill now. So
Right.
sometimes kids think they've heard enough or they know enough that, well, I'll
Right.
just do this and it'll be fine. Well, it isn't. Oh, and one more thing to let your clients know is, even though federal tax regulations have a yearly gifting exclusionary amount, I think it's 16,000 now that mom or dad can gift to the kids.
Mm-hmm.
Medicaid does not work with federal law. So
Wow.
although the federal government says you can do gifting to your children,
Mm-hmm.
Medicaid sees you've been gifting to your children, even though it was in accordance with federal IRS tax law guidelines, they will penalize you. So you're penalized for every $9,600, I think it just went up, $9,800 that you give away. That's 1 month they're not going to pay for Medicaid. So if every year you've been giving away, say, $30,000 to the kids, because it's
Mm-hmm.
okay, according to the IRS tax rules, it's not okay according to Medicaid. And you're going to get stuck in a huge penalty. So please, please, please talk to a professional. Call
Mm-hmm.
the angels. We will help you through all of this, because it is very befuddling when you start looking at it all.
Yes, thank you, Daphne, so much. What would be the best way to reach you if clients wanted to connect? Is it through your website? Is it calling you? What would be the best way?
Sure, you can go online to HWK Law Group's website, and there is a link specifically to Angels, which is our department that specializes in long-term care Medicaid planning, or just call the office directly at 410-825-2255. My assistant, Jan, at extension 125. We actually, gosh, she's been with us for at least 15 years now. She started
Mhm.
out as a client. We were helping a family, her family. So she started out as a client, and it's great because when she talks to the new people calling in, she gets it. She's lived it.
Yeah.
My business partner, Sherry, she's lived it. She went through this with her grandmother in a nursing home and a grandfather. So we've all been there and done something in the elder realm for our own personal families. So
Okay.
we are very empathetic to what these people are going through.
Very good. Well, thank you so much, Daphne. I think you hit all of the questions I had and answered them so thoroughly. I do appreciate it. I will be reaching out to you separately for some things I have to work on from a personal note, but I do want to thank you for your time, and thank you for just giving me the support so that I can support my clients.
Absolutely. Absolutely. I am happy to keep educating people so that they don't make those mistakes and end up in trouble. So let's get them to a professional that can get them on the right path, and mom and dad taken care of, and everything goes nice and smooth. A little bit of pre-planning goes a long way.
Absolutely. And I'm so happy to have met you. I have to say this because this is not my lane. I don't claim to know it. I send people to websites usually for power of attorneys and things, and then they come back to me and ask questions about it. And I'm usually like, I just don't know. And, like you said, I kind of think I know a little bit because I've been in elder care for about 20 years. But I mean, you've shocked me. You've kind of opened my eyes with so many things just in this conversation. So I'm happy to kind of slide those clients as soon as they start that conversation over to you and your group so you can help them so that they'll be on the right track and they're not kind of running around trying to figure it out on their own. I definitely appreciate appreciate it. And I see the value always in having a professional to set you up, because once it's done, it's done. You know, you don't have to worry about it, you know, and it's done right. So yeah, that's
It
good.
just makes everybody's lives a lot easier if that
Right.
little bit of pre-planning, especially when I've got kids who are still raising their own children and now
Yeah.
mom's come to live with them, but needs the nursing and they're just overwhelmed. They're working, they're raising their own kids and they're taking care of mom and they are so overwhelmed. So please just give me a call. I will
Yes.
help.
Yes.
We will
Okay.
fix it.
Perfect. Thank you. Thank you, Daphne, so much. Again, I appreciate it. Thanks for joining me on this Saturday morning, and I hope you have a wonderful rest of the weekend.
Thank you. You do the same.
All right. Take care
All right.
now.
Bye-bye.
Bye-bye.